Do we have a signed trial agreement? I see there's an advice. Oh, we do. Great, thank you. All right, Nancy, you ready? Thank you.
Thank you.
So we are back on the record, and this time we're taking up the case of People of the State of Michigan versus Andrew Donald Young. The case number here is 26-3672 FH. Appearances, please.
Thank you very much, Your Honor. Attorney Robert Ringstrom, the Assistant Prosecutor for Missaukee County.
Robert Hertzell from Mr. Young, who joins me to my left.
All right, thank you. You may be seated. So we are here today for a pretrial conference. The court has received from counsel a written pretrial agreement and an advice of rights. And I've got a police report being handed to me now, and therefore that tells me we've got a no contest plea. All right, so we're going to make some changes here. I'm sure it's not, I'm sure it's an oversight, but the pretrial agreement mentions pleading guilty, but it's going to be no contest. Is that correct, Mr. Hartel?
It is, Your Honor.
And Mr. Ringstrom, no objection, I assume?
No objections. We were just notified today, Your Honor.
All right, thank you very much. And is that for what reasons? Civil liability and or consumption? I see.
It's consumption.
Okay, thank you very much. Great. Mr. Young, please raise your right hand. Sir, do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
Yes.
You may lower your hand. Mr. Young, looking back to just about a month ago on April 3rd of this year, were you on probation or parole anywhere?
No, I was not.
Were you on bond pending any felony charges anywhere?
No, I was not.
You are charged today on a felony information with 4 counts and some sentencing enhancements. We're going to go over those counts, and then we'll go over the terms of the pretrial agreement. Count 1 is a charge of assault, resist, obstruct a police officer. Now that's a felony punishable by up to 2 years and or up to $2,000. Did this occur in a jail? I'm assuming no. Now there's a sentencing enhancement there called a 4th habitual felony offender. That could, upon a finding of guilt, within the discretion of the court, increase the potential punishment from up to 2 years to up to 15 years. However, I'm told today that you are going to plead no contest to that count. And if you do, and I accept that plea, the prosecutor will dismiss the 4th habitual felony offender enhancement. Count 2 is a charge of escaping lawful custody, which is a misdemeanor punishable by up to 1 year and or up to $1,000. But I'm told today that that count will be dismissed. Count 3 is a charge of operating while intoxicated or impaired as a second offense. Now, initially, an operating while intoxicated is a misdemeanor punishable by up to 93 days and or a minimum of $100 to a maximum of $500 in fines and costs, plus 360 hours of community service, vehicle mobilization if you have, of course, and cost of prosecution. However, it's charged as a second offense. That means it's still a misdemeanor, but the maximum punishments change. It's a minimum of $200 to a maximum of $1,000 in fines plus costs, and a mandatory minimum of 5 days to a maximum of 1 year in jail. And there could be between 30 and 90 days of community service, plus rehabilitative programming, the cost for prosecution, and the cost for any emergency response, as well as vehicle immobilization, which is mandatory. I'm told today that you are going to plead no contest to that count as well. Count 4 is a charge of domestic violence as a second offense. Typically, domestic violence for a first offense is a misdemeanor punishable by up to 93 days and or up to $500 in fines and costs. As a second offense, it's still a misdemeanor, but the maximum punishments are increased to up to 1 year and or up to $1,000. However, I'm told today that you're going to plead no contest to that count as a first offense, which means that it will only be up to 93 days and not up to the 1 year. Also, there's a part of the agreement that apparently